Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a spectacular and very, very needed webinar on the topic, Lien Waivers in Arizona, be careful what you sign. And without further delay, I would like to introduce the fabulous construction attorney, Kevin Estevez.
Thank you, Ariella. Good morning, everyone. Like Ariella said, I am Kevin Estevez, and this is our third part in the series of webinars on Arizona construction law. So with that, we're going to talk about lien waivers today, and we'll jump right in. If you have any questions, please feel free to shoot those questions over via the chat box, and we will address those at the end. Before we jump into today's topic, I'd like to do a brief recap of the subjects we discussed on the last two installments of our series here. And basically, we discussed how to preserve mechanics lien rights in Arizona. And the first and probably most important thing to do is timely serve a proper preliminary 20-day notice. We went over that in detail in the first webinar, and I point you back to that webinar to look at and see what we talked about there. The second thing that we talked about generally, and we didn't really dive into great detail on, was not forfeiting lien rights by signing an improper and or incorrect lien waiver. And I've highlighted that here on this slide, and that's what we're going to talk about today. Also a very, very important step and something to be very mindful of as you're navigating the lien process. The third thing we talked about is timely record a statutorily compliant notice and claim of lien within the county, with the county recorder within the county where the project is located. The next step we talked about, and this was part of our second webinar, what we do after a lien is recorded. You get to timely serve the notice and claim a lien, and then lastly, sue to foreclose the lien within 6 months of recording. So that is a brief recap of the subjects we've already discussed, and with that, we'll jump into our topics for today, which are lien waivers in Arizona generally. And after we get done talking about that, we'll talk about and go through each of the 4 different types of specific forms of lien waivers used in Arizona. And lastly, we'll touch on lien waiver do's and don'ts. Lien waivers in Arizona generally. In Arizona, lien waivers are creatures of statute. And when I say that, I mean they are specifically, the types and specific forms of lien waivers are delineated in ARS 33-1008. And Arizona provides for basically 4 types of lien waivers, which can be grouped together in a couple different ways. You have conditional waiver and release on progress payments. You have unconditional waivers and releases on progress payments. You also have conditional waivers and releases on final payments, and unconditional waivers and releases on final payments. And you know, I guess you can segregate these by whether they're progress waivers or whether they're conditional or unconditional. And I think a good way to think about it is you think about a graph with 4 quadrants, and you have the x-axis running horizontally, and everything above the x-axis would be progress waivers, everything below would be final, and then you have the y-axis, and everything to the left of the y-axis would be conditional, and then everything to the right would be unconditional. So there's some overlap in these various waivers, and we'll talk about that as we go through. One important thing to note and to be very mindful of is that waivers in Arizona have to substantially follow the statutory forms within ARS 33-108 to be enforceable. They don't have to exactly comply, and there may be circumstances that we talk about where you want to deviate from the form in a small way, but you have to bear in mind that they need to substantially comply with the statute, or else they will not be enforceable. So the first way to group the different waivers together are progress versus final waivers. As the slide here shows, progress waivers are used when a lien claimant is required to execute a waiver and release in exchange for or in order to induce the payment of a progress payment. Generally, progress waivers only release lien rights for a specific period of time. The flip side to progress waivers would be final waivers, and these are used when a claimant is required to execute a waiver and release in exchange for or in order to induce payment of a final payment. And generally, final waivers release all lien rights on a project, except for disputed amounts that may be specifically listed, and we'll talk about that when we get to the statutory forms of final waivers. The next way that you can group the different forms of waivers are conditional versus unconditional. Conditional waivers are used where a lien claimant is required to execute a waiver and release in exchange for or in order to induce payment, and the claimant is not in fact paid in exchange for the waiver and release, or a single payee check or joint payee check is given in exchange for the waiver and release. Conditional waivers are only effective if the payment identified in the waiver is made. And a good, simple, and general way to think about conditional waivers is a conditional waiver plus payment equals an unconditional waiver to the extent of the payment made. An unconditional waiver is not operative until you actually receive the payment specified therein or a portion of it, and then it's only operative to the extent of the payment made. So that is a good way to think about unconditional waivers. They can, even though they're conditional, they certainly can become binding once the payment reflected therein is made. The next category here is unconditional waivers, and these are used where a lien claimant is required to execute a waiver and release in exchange for or in order to induce payment, and the claimant asserts in the waiver that it has been paid the payment. As you'll see in the specific language that's contained in the statutory forms, unconditional waivers are effective, generally speaking, even if the payment identified in the waiver is not made. And the language in the waiver is clear that when you sign these, you're saying that I've received the payment, and so they can be operative even if the payment is not made, which can present some real concerns for folks in the construction industry. Moving on, what I have here is the statutory form of the unconditional waiver and release on progress payment. So this is conditional and it relates to progress payments. And I've highlighted certain sections of the release to draw your attention to them. In the first couple lines, I've highlighted portions here that say on receipt by the undersigned of the check, and then there's some specific information that needs to be filled in about the maker of the check, the amount of the check, and who's receiving the check. And then it says, and when the check has been properly endorsed and has been paid by the bank on which it is drawn. So this is the conditional part of this unconditional progress waiver. Basically, it says that once you receive the check and the check clears, then this document becomes effective to release any mechanics lien, any state or federal statutory bond right, any private bond right, and so on. So again, this gets back to the equation that I talked about earlier, where it's the waiver plus the payment equals the conditional waiver plus the payment equals an unconditional waiver to the extent of the payment. And then the second highlighted section that's a little bit further down here says this release covers a progress payment for all labor, services, equipment, or materials furnished to the job site or to and then it leaves a space for the person with whom the undersigned contracted through a specific date only and does not cover any retention, modifications, and changes or items furnished after that date. And as we talk about do's and don'ts for lien waivers in a little bit, we'll talk about the importance of the dates filled in here, because as you can see, if you fill this out properly, you are waiving lien rights up until a certain point in time, not including retention, pending modifications and changes, or items furnished after that date. But if you do put an incorrect date in here, there's potential for problems to develop and potential unwitting waiver of lien rights. Moving on, the next lien waiver statutory form we have here is the unconditional waiver and release on progress payment. And so again, we're talking about progress payments, but different from what we just reviewed, this is an unconditional waiver. And you can see that distinction in the first line here where it says the undersigned has been paid and has received a progress payment in the sum of, and it leaves a blank spot. So this document, when you sign it, you are signifying that you have been paid. But consistent with the language from the conditional progress payment, the second section here, again, only releases lien rights through a period of time that hopefully corresponds with the progress payment app that was submitted, and again does not cover any retention, pending modifications and changes and items furnished after that date. So it is a release up to a specific period of time. And then the last section that I highlighted here on the bottom of the statutory form is what I talked about earlier. This is a notice that's required to go into unconditional waivers by statute, and it's actually required to be in the same size as the largest font otherwise in the document. And this notice here says that this document waives rights unconditionally and states that you have been paid for giving up those rights. This document is enforceable against you if you sign it, even if you have not been paid. If you've not been paid, use a conditional release form. So that document is, or that notice is plastered on the form of an operative lien waiver, an unconditional lien waiver, and it should serve as a warning that you should not sign unconditional waivers unless you have been paid and that payment has cleared. Otherwise, there's you're setting yourself up for a potential pitfall. The next statutory form of waiver we have here is the conditional waiver and release on final payment. So again, we're back into the conditional section of the graph, and now we're talking about, as opposed to progress payment, final payment. So the first section I've highlighted here says on receipt by the undersigned of a check from the maker in the sum of blank dollars, and when the check has been properly endorsed and has been paid by the bank in which it is drawn. So this is the same conditional language that we saw from the first statutory form of waiver that we looked at, which was the conditional waiver on progress payments. But down here further, the second highlighted section is the final payment section. So it says here, this release covers the final payment to the undersigned for all labor, services, equipment, or materials furnished to the job site or to, and then it lists a blank spot for the person with whom the undersigned contracted, except for disputed claims in the amount of, and then it leaves a blank spot there. And so what you want to take away from this is that again, it's conditional and it's not operative until the check is received and the check clears the bank on which it is drawn. But it once that happens, it releases lien rights finally on the project, except for disputed claims that you list here. And so to the extent when you get to the end of a project, there are disputed claims, you want to make sure those are reflected in your final waivers, whether they be conditional or unconditional. And so that will move on to unconditional waivers and releases on final payment. And so this is the last of the 4 statutory forms of waivers that we'll talk about today. And again, this is the first highlighted section here, is the unconditional language of this release. It says the undersigned has been paid in full for all labor, services, equipment, and material furnished to the job site. And then the second portion I've highlighted a little bit further down talks. It's the disputed language that talks about, again, so this is an unconditional final, and the language here is again calling for the lien claimant, potential lien claimant, bond claimant to include disputed amounts for extra work. Otherwise, this fully waives lien rights on the project. And as we saw with the unconditional, waiver and release on progress payment, this again includes the notice at the bottom here where it says, hey, this document waives rights unconditionally and states that you've been paid for giving up those rights. This document isn't enforceable against you if you sign it, even if you've not been paid. So again, you don't want to sign an unconditional waiver and release on final payment unless you have, number one, been paid and you are sure that the payment has cleared. So those are the four statutory forms. And again, for a lien waiver to be operative in Arizona, it has to substantially comply with these forms. And now that we've gone over the four different types of waivers, let's spend some time talking about lien waiver do's and don'ts. The first do is to exercise extreme caution when executing any lien waiver. These documents can potentially have catastrophic consequences if they're filled out incorrectly or if the wrong type of form is used. So you want to make sure that you're being very diligent when you're reviewing lien waivers. You want to make sure that they comply with the statutory form, and you want to make sure you're signing the second point here. The third do here, a document, which is be mindful of the time period because covered by prospective progress waivers. And you'll see this happen on occasion where a contractor or supplier is asked to sign a waiver, a progress waiver, up to a certain period of time. And typically, provided that the payment schedule remains on an ordinary course and it's consistent with the payment obligations set forth in the party's contract or Arizona's Prompt Pay Act, depending on what governs. In most cases, it'll be the Prompt Pay Act. That should not be an issue. Where you run into an issue is where you have a disputed pay app. And so a contractor will submit, say pay app 2, and there'll be a dispute on that, and the parties will go back and forth. And while that is being ironed out, then the contractor will submit a pay app 3. And in connection with pay app 3, they may submit or they may ask to be asked to fill out and resubmit a conditional progress waiver up through the point in time with the third pay app. Well, if the second pay app hasn't been squared away and that's not delineated somewhere in the waiver, and the contractor is signing a conditional waiver saying if they get paid X number of dollars for pay app 3, that they're giving up all lien rights up until the period of time covered by pay app 3, the contractor could or supplier could find themselves in a difficult situation and may have unwittingly waived lien rights, bond rights for the disputed pay app 2 that hasn't been resolved. So be very mindful of the time periods covered by progress waivers, and be mindful of potential disputes and amounts that have remained unpaid on previous waivers, and think about those as you are approaching and contemplating lien waivers for subsequent payments. If you are at all unsure about whether or not to sign a waiver and the potential consequences it may have, I would suggest that you seek legal assistance. Talk to an attorney about these things, and hopefully you can then sort through the issues that you're facing. Lien waiver don'ts. The first one I sort of touched on here, and going back through the different forms of waivers, specifically the unconditionals. Don't ever sign an unconditional lien waiver until you know that the payment you have received has cleared. And so number one, you want to make sure that you have the payment, and then number two, you want to make sure it has cleared. And a lot of times when things are going smoothly on a construction project, and you know, there's maybe a good relationship, sometimes people will be asked to sign unconditional waivers in exchange for a check. And that's not the role of an unconditional waiver. Unconditional waivers should be signed after that check is cleared. If you're being asked to submit a lien waiver in exchange for receiving a check, it should be an unconditional waiver. And that way the person upstream, the owner, who what have you, will be protected, because they'll have a waiver that once it's combined with the payment they actually make will be operative as an unconditional. And you as a contractor or supplier have not unwittingly signed away lien rights before a check has cleared or before you have received payment. So that is a big don't. Unconditional waivers should only be signed after the payment's in your hand and you're sure that the payment is good. Now, some folks will say, well, you know, there's if the party upstream issues a bad check, you would certainly have, you know, breach of contract or bad check remedies. But signing that unconditional waiver can limit your ability to recover against different parties. And what I'm talking about here is specifically an instance of, you know, say you're a subcontractor and you're working on a project, and you have a general contractor who may be going through some rough financial times, and you sign an unconditional waiver before you receive or before you confirm that a check clears, and the check bounces, and you may have claims against the general contractor for the bad check, like I just mentioned, or for breach of contract. But arguably, in that instance, you would have waived your lien rights on the project, and that can preclude you from potentially pursuing the owner and your lien claim on the property, which would be an alternative source of recovery if in fact the general contractor is experiencing financial difficulties and maybe not be able to satisfy the amounts they owe you. So you would still have potential recourse, but may not be the recourse you would otherwise have. And then the last point on lien waiver don'ts is don't neglect to include disputed amounts in final waivers. And we looked at the final waiver forms in detail, and as I'm sure you noticed, and I think I pointed out, on both of those forms, there is the spot at the end where it says, hey, you're giving up all rights on the project except for these disputed amounts. So make sure if you get to the end of a project and you're asked to submit a conditional final or an unconditional final, and there is a dispute over certain amounts, that dispute is reflected in that waiver. Because if you don't list it, you may have and likely have waived the rights to those amounts. So that is a brief overview of lien waivers in Arizona. And with that, I will turn it back over to Ariella, and certainly welcome any questions. Oh, and I apologize, Ariella, correct me if I'm wrong. You guys do have statutory compliant lien waiver forms available through your website, correct?
Yes, we do. So if anyone is using the SunRay portal to request their preliminary notices, they can certainly request all of those documents through the system. But this webinar certainly helps them in making smart decisions. We do have a question that you basically have answered. And this is a really interesting question because there is a little hook to it. So the question is, what are your thoughts on signing unconditional waivers sent to a third-party payment management system, for example, Textura? Very often, Textura requests a signed unconditional waiver, stating that it will hold the waiver until the contractor makes payment, as though the waiver is held in escrow. It's a great question.
That is a great question. And you know, I think probably you're afforded a little more protection if it's held in escrow. I still would be nervous about submitting it and having that out there with a signature on it. Because I think if you get in litigation over these things and you have that submitted to a third party like that, that third party's records can certainly be subpoenaed, and then you have this waiver that's an unconditional waiver out there that's signed, arguably giving up your rights on the project. I would be. I think that, of course, you would, I think, in that circumstance, have arguments that, well, no, it's being held in escrow, and that was the deal that was struck between the parties, that it wouldn't be released until payment has cleared. But I still think, at least in Arizona, that's not consistent with our statutory scheme. And I think in that situation, you're still better off as a contractor to submit a conditional waiver and then wait for the payment to clear, and then with your next payment application or further on down the line, after that payment has cleared, you can then go ahead and submit the unconditional.
You know, I have a follow-up question, because if I were this company, this would be my question to the attorney, to you. So what happens is we all know that he who has the gold rules when it comes to waivers and releases, unfortunately. Do you think that's a fair statement? So if they require you to sign things, right? So in this situation for this company, what would you recommend so that there's a way around it, if any? Is there something that you would suggest to this company? Because they may say, no, I'm sorry, this is the way we handle our business. Is there something that you suggest?
Yeah, you know, I think that you would insist on following the statutory forms, and say, you know, we have Arizona has a statutory scheme that provides for waivers to be handled in a certain way, and you know, it's our policy to comply with that. I think that would probably be the best mechanism for handling a situation. And then, I mean, I think that generally speaking, that's.
Yeah, I hear you. I think another point that we can make to the end user signing these waivers is that it's essential that if you're working on a massive project, that at the beginning, when you have a signed agreement, that you are agreeing upon waivers and not waiving too much of your lien rights at the onset, and putting yourself in a position of strength versus weakness in the middle of a project when things are starting to go sour, not because of anything a sub or a supplier did, but because something happened. So I think that initially you want to make sure in your contracts you have the language that you need for your waivers. Would you say that's a fair statement?
That's a fair statement, yes. And I think that's certainly on the front end of any project. You want to make sure that you're going through the construction contract and make sure you're comfortable with the forms of waivers that are being required. And you know, you see construction contracts that sort of run the gamut on what they require, and there's ways to negotiate that on the front end to make sure that you're not facing that issue, like you said, Ariella, as the project gets going.
Okay. To the person that asked that question, have we addressed your concern? And you could certainly write a response in there. And while you do that, is there anyone else that has any questions regarding waivers and releases? And if you don't have any right now and something, okay, very good. I'm happy that was helpful for you. And if anyone has any questions at a later point, they always happen for some reason after the webinar. It comes up like, oh goodness, I forgot to ask this question. I believe in our next slide, we have our contact details where you could reach Kevin directly. Yep, there it is. So if you have any additional questions that pop up later, feel free to ask us at any time. For everyone on our webinar, I wish you, first of all, Kevin, spectacular job. And for everyone else, I wish you a sunny day.
Thanks, Ariella.
Thanks so much.